Ready? Exercise number 13, legal matter. Very important matter, and this exercise includes 1000 words. Start writing. It is doubtful as to whether, against the order of acquittal by the learned session judge, an appeal has been filed in the High Court, as neither the number of appeal nor its date of filing has been informed by the standing counsel. It is admitted fact in the supplementary counter affidavit that as a consequence of the impugned order, the juniors to the petitioner had been promoted and were granted selection grade, against which a representation was also made by him. But the same was denied on the ground that an appeal is prepared to be filed by the state. Stop, next para. In the supplementary counter affidavit filed on behalf of the respondents, it is averred that information regarding proposal of filing of appeal against acquittal is being initiated as received from Vigilance Department, and that the appeal so proposed might have been forwarded by the DGC (criminal) out, though the legal remembrancer state of UP for being filed in High Court. It is averred in paragraph 5 of the supplementary counter affidavit that according to the opinion of District Government Council, non-payment or withholding of retirement benefits of the petitioner is illegal. Stop, next para. In paragraphs 4 and 5 of the supplementary rejoinder affidavit, the petitioner has taken a stand that there has been no departmental inquiry proceedings against the petitioner, and as he has been acquitted in the criminal case, withholding of his promotional and financial benefits is illegal and arbitrary. It is stated that he is not aware of filing of any appeal by the state governments, the order of acquittal dated 31/1/2005, and even if appeal has been filed, it has no relevance for withholding his retirement benefits due to him, particularly in absence of any departmental inquiry having been held against him. It is urged that the entry of doubtful integrity is automatically washed off on acquittal, and as such the opinion of DGC is not correct. Stop, next para. The admitted facts further culled out from the record and the arguments of the parties are that the petitioner has been acquitted by the learned session judge on the going that the charges are not proved against the petitioner. Admittedly, no domestic inquiry whatsoever was held. It is settled law that no person is guilty unless charges are proved. Since appeal is a continuation of the proceedings of the court below and the petitioner has been acquitted therein, the petitioner cannot be punished either on the ground that Vigilance Office at Lucknow recommended for withholding the integrity of the petitioner in 1993 after about 8 years for the year 1984 to 85, when in fact adverse entry had been given to him in that year and in subsequent years. Stop, next para. Once the court has rendered a judgment, then it is to be honored, and it can only be set aside by a superior court of law. The District Government Council cannot sit in appeal over the judgment of the superior court and for withholding of retirement benefits on the ground that appeal against acquittal is being proposed to be filed in the matter or had been filed. If any appeal filed against acquittal is decided in favor of the respondents, natural consequences from it would flow, but till acquittal is continuing and is not set aside, punishment cannot be held pending decision in appeal. Lastly, the petitioner was neither provided report of the vigilance inquiry nor the same has been produced in court. A person cannot be denied to challenge an inquiry report on basis of which he has been visited with serious consequences and which tarnishes his image and status in the society on the ground of confidentiality. He could have been also proceeded with departmentally and has every right under the Constitution to defend himself. Thus, in spite of acquittal, the petitioner was not only given adverse entry of withholding of integrity for year 1984 to 85 after about 8 years on the dictates of the vigilance officer at Lucknow, but was also further punished by denying him selection grade in admitted backdrop that his juniors had been granted the same after 10 years of service. Not only his retirement benefits have been withheld, but moot question before the court is as to whether after his acquittal in the criminal case could their separate punishments have been inflicted upon him on dictates of the vigilance office and upon the opinion of the DGC. From the averment made in the counter affidavit, it is apparent that the petitioner has been superseded and has neither been granted selection grade after completion of 10 years of service pursuant to the government order dated 3/6/1989 as referred to in the office order dated 9/12/1993, nor retirement benefits have been paid to him. Thus, it is clear from the above that the petitioner was neither a spy nor was asking for any secret information from the Vigilance Department or the board. On one hand, he is being punished with major punishment, and on the other, he is denied opportunity to clear himself of charges by challenging the order of withholding increment which had been passed on the dictates of the Vigilance Office at Lucknow. By not providing him the report of vigilance inquiry on the basis of which his integrity had been withheld and which could have been challenged by the petitioner before the court of law. Such consecutive actions to throttle no dues of a citizen of free India in spite of this acquittal cannot be permitted by any court on reasonable standards. The action of respondents suffers not only from vice of non-transparency but also from arbitrariness, illegality, and against principles of natural justice. The amendment application of the petitioner moved subsequently for selection grade has already been allowed by order dated 9/4/2008, and the petition has been amended accordingly. For the reason stated above, the writ petition succeeds and is accordingly allowed. The impugned order dated 12/8/1993 is quashed. It is further directed that since the petitioner has now retired from service on 31/1/2006, therefore he will be given notional promotion and all the retirement benefits at least at par with the person who is next below in the seniority to him. The petitioner will be given pensionary benefits along with 6% interest in accordance with law within a period of 3 months from the date of production of a certified copy of this order. Full stop. Thank you very much. Guys, there is one humble request. Please try to repeat the matter so that your fluency and accuracy will improve. And also there is one more request. If you found the matter is excellent for exam purpose, you can give your valuable comment on my YouTube channel. And there is one humble request, guys. Please subscribe my channel for next audio like this. Thank you very much.